Hey everyone, welcome back to the channel. Today we are diving into a very important aspect of Singapore's legal framework, the Single Application Pending Trial or SAPT under the new rules of court 2021. Whether you're a lawyer, a law student or just someone interested in the legal processes, this video will break down what the SAPT is, why it was implemented, its rationale, the benefit it offers and some criticisms it has faced. First, let's cover what the SAPT is. Under the new rules of court 2021, the Single Application Pending Trial is a streamlined mechanism that replaces the previous multiple interlocutory application process. Instead of having various separate applications to resolve different procedural matters such as amendments, discovery, striking out claims, the SAPT consolidates all interlocutory applications into one single application. This is part of Singapore's broader initiative to modernize and simplify litigation, aiming to save both time and costs. Now let's talk about why this change was necessary. Before 2021, the litigation process, that means the lawsuit process, was often bogged down by numerous interlocutory applications. Interlocutory applications are court applications made before the trial on various matters. This not only delayed proceedings, but also increased legal fees for clients. It could take months, sometimes even years for a case to proceed to trial because of all these pre-trial applications. SAPT was introduced to combat this inefficiency. The idea is simple. By consolidating all interlocutory matters into one application, cases can proceed to trial faster and the courts can better manage their caseload. The main purpose of the SAPT is to avoid piecemeal litigation. The courts want to encourage parties to bring forward all interlocutory matters at once, rather than applying for them separately over time. This makes the process more predictable and manageable, allowing both parties and the court to deal with all pre-trial issues at one go. It aligns with the overarching goal of the Rules of Court 2021, which is to ensure procedural fairness while maintaining efficiency. Now let's explore the benefits of the SAPT. Number one, by consolidating all interlocutory matters into one application, the SAPT significantly cuts down on delays that typically arise from managing separate applications. Number two, cost effectiveness. Fewer applications mean lower legal fees, benefiting clients who might otherwise be paying for multiple interlocutory hearings. Number three, the courts are able to manage their docket more efficiently to prevent a backlog and ensure timely access to justice. Number four, the SAPT provides a clearer, more streamlined approach for lawyers to prepare their cases. They are now encouraged to focus on resolving all procedural matters upfront. Of course, no system is perfect. The SAPT has received its share of criticisms from both lawyers and legal academics. The first criticism is inflexibility. One of the main criticisms is that the SAPT may be too rigid. Lawyers have pointed out that certain cases require a more nuanced approach, and consolidating all interlocutory matters into one application might prevent them from addressing issues that arise later subsequently. Another concern is the potential increase in workload at the initial stage of proceedings. Lawyers are required to anticipate and deal with all interlocutory issues from the outset, which might increase preparation time early on in the case. Some argue that the SAPT limits strategic flexibility. In the past, lawyers could wait and see how certain aspects of the case unfolded before deciding whether to file certain interlocutory applications. Now, that flexibility is diminished because the SAPT forces lawyers to think about everything they need to do and every application they need to take when the court directs the SAPT. So for example, if you're not sure whether a potential witness is willing to testify, you have to think whether you wish to make an application for a subpoena during the SAPT. Finally, critics worry that by dealing with everything at once, some issues might be overlooked, or worse, the court could make hasty decisions without fully considering the complexities of individual procedural matters. So there you have it. The Single Application Pending Trial is a powerful tool designed to make Singapore's litigation process more efficient. But like any procedural innovation, it comes with trade-offs. While it reduces delays and costs, it also demands more upfront effort from lawyers and clients. Thank you for watching. Don't forget to like, share, and subscribe, and I'll see you in the next video.